Hi, I'm Myles Johnson. Today I want to talk to you about a common question that I get asked by many clients. Can I have the other party pay my attorney fees? The answer to that question is it depends. There's usually two circumstances in a divorce or custody case where attorney fees come into play. One is the economic circumstances of the parties. So what the court wants and the legislator has supported is that parties are on an even playing field. So if wife is making $200,000 a year and husband's only making $60,000 a year, they're living separate and apart, and they're both having to pay their own fees, it's a much higher burden on this person than it is the other. So in that situation, a request from the court saying, hey, we both had to spend all this money, except for it stings a bit more on this side because of the totality of the economic circumstances. The court can and often does provide some sort of reimbursement of the attorney fees. Be sure you caught that, reimbursement. That means that the fees were paid, right? So this isn't upfront necessarily. The fees were paid, and the court says, hey, husband, you have to pay 50% of her fees back to her, right, to get you on the same level playing field. Another situation is when basically parties are in the wrong. They're taking positions they shouldn't take. They're groundless, baseless, frivolous, vexatious, and they don't further the proceeding, right? One example would be disclosures. If a party was just refusing to make disclosures, and the other person is having to spend attorney fees to ask for information that should have been provided a long time ago, the court can look at that situation and say, hey, that person shouldn't have had to pay fees for the other person to do what was expected of them. Yeah, you're going to have to pay them those fees back. Or taking a position that's groundless, and there's a lot of gray area into when is a position groundless or not. Mother might believe that she should be primary parent, father believes that he should be primary parent. It's tough to say that either one of those arguments are groundless on their face. However, you throw in different circumstances or a different set of facts and it obviously becomes groundless. If father is deployed in the military and knows that he cannot take care of this child because of his obligations, and he's still requesting that the child lives with him full time, yeah, it starts to skirt towards that realm of frivolous, right? Groundless. So those are two scenarios where a court is going to order a reimbursement of fees. There's also this third scenario that's used somewhat rarely. It's a request for prospective fees. That's at the beginning of the case. One party says, I can't even get through this case because I don't have the money to do so. The other party does. Therefore, court, grant me $10,000 in prospective fees so that I can have proper legal representation throughout this case. Those happen on rare occasions. Courts, it really depends on the court and the judicial officer how much play and legway you'll get with those types of arguments. But know that is an option, and it may need to be explored in your situation.